According to the Constitution Implementation Commission, the Leadership and Integrity Bill left Cabinet mutilated and that Parliament passed it without making any improvements. CIC's next course of action was to advise the President not to assent the bill into law, but its advisory was overtaken by events after the President appended his signature to the bill.
Where we have reached now, the answer to the issue on the table can only be resolved by the court.
Article 99 of the Constitution states that a person is eligible for election as a Member of Parliament if they satisfy any educational, moral and ethical requirements prescribed by the Constitution or by an Act of Parliament. The educational qualifications, according to the Commission, have been taken care of by the Elections Act. It was anticipated that the Leadership and Integrity Act would tackle the ethical and moral aspects.
The Act, as it reads at the moment, actually fails to meet the contemplation of the Constitution and therefore will not, in our view, serve the purpose and therefore cannot be the legislation that is contemplated in Article 80.
Article 80 of the Constitution says that Parliament shall enact legislation establishing procedures and mechanisms for the effective administration of Chapter 6.
So the position of CIC at the moment is that the law that is contemplated in Article 80 of the Constitution is yet to be enacted.
Chapter 6 of the Constitution, which deals with leadership and integrity, essentially throws a dragnet to catch all those who fail the integrity test to prevent them from being elected or appointed as leaders.
If non-compliance with Chapter 6 is not self-evident or nobody raises it, the first possibility is you might go through the net.
And the Commission is determined to ensure this does not happen. Hence its decision to seek legal redress. Sylvia Chebet, Citizen Live at 9.